Hello friends, welcome to Let's Crack UPSC CSE English. This is me, Dr. Sidharth Arora. And friends, we are continuing our series of Laxmikanth summaries, and till the last video we had started with fundamental rights, but we dealt with only article 12 to article 18. So I have divided the entire topic of fundamental rights into small parts so that you are able to understand them in bite-sized videos. Number one. Number two, I am able to do justice with whatever I am trying to impart to all of you. Now, in this sequence, there are two things which are very, very important for all of you who are watching this video right now. Number one, this video is specifically, this channel actually is specifically made for those of our aspirant friends who are not comfortable in understanding Hindi language. So those of you who are comfortable or who prefer Hindi language or a mixture of Hindi and English, the same video, the same chapters, the same sequences, the same courses will be dealt and have already been dealt in our other channel, which is called Let's Crack UPSC CSE. So you might as well choose to watch the same video in that channel. This is specifically catering to the needs of those aspirants who are comfortable only in English language. So many of our aspirant friends have requested us several times that they are not comfortable, they are not understanding Hindi language. We at Unacademy do not want language to be a barrier, hence we have made this channel for all of you. Number two, that we are making summary courses of Laxmikanth, but it is very important that all of you also understand the limitations. The one limitation is, yes, Laxmikanth is a fab book, it's an awesome book, but it is not the answer to everything that is required for civil service examination. Yes, it will take care of about 30 to 40% of prelims, but nothing more than that. So please ensure that you have a full 360-degree preparation view and strategy. You have to do current affairs, you must read from other sources, you have to be abreast with what is happening and how do you connect the dots. This is very, very important for all of you to notice. And in that sequence, we are now doing the second part of our fundamental rights portion. We are now today going to look at only Article 19. Sir, is Article 19 only one article? No, actually the sub-articles, Article 19, 1A, B, C, D, E, F, G actually deals with about 7. Okay, we will do 6 of them in detail, but 7 fundamental rights. So I want you to be paying attention to this Article 19. It is amongst the very important articles of your fundamental rights. So why are we doing all this? We are all doing this because we have a single point agenda that we want to help you out in any which way possible. We want to help you out in getting a realistic chance of passing this exam. It is one thing to appear for this exam and to fill up the forms and start imagining and wishing that you will pass this exam. The other one is to do a strategic preparation which gives you a realistic chance of passing this exam. In this context, I want to announce for all of you that we have launched what is called as a comprehensive course of polity. This is called as comprehensive course on polity for UPSC CSE 2021. Please make a note of it. This course is starting on 11th May 2020. We are launching this course, and as the name suggests, it is going to be intense, it is going to be complete, it is going to be comprehensive. From 11th May to 3rd July, I will be taking these classes along with several other, all other polity educators and all other subject educators will also be teaching you this. What is the single point agenda? That you should have 24-karat rock solid preparation so that when you really go for the exam, you should be prepared to whatever is best possible. The interesting part here is that Unacademy has drastically reduced the prices of the subscription. So those who are appearing for this exam in 2020, please choose a 12-month subscription, or which is available for 40,000 rupees. In this, you can use my code SID10, SID10, or you can also use SID Live, the ones like I have shared in my previous videos. Both of them are applicable. Use SID10 and you will get an immediate 10% discount, and you will get this same course for 36,000 rupees. Those are my friends who have more than 2 years. So they are appearing in 2021, 22, 23, or for that matter, even 24. Again, use this code SID10 and choose 24-month course, which is available for 48,000 rupees. The moment you use my code SID10, SID10, you will get a 10% discount and you will get this course for 43,200. Do some maths, my friends. This 1-year course is for 36,000 rupees. 2-year course is for only 7,200 more. That is 43,200. You're a wise gang of students. Take a wise decision, but take your decision now. Don't wait unnecessarily. Today's topic. We are doing Article 19. I am happy to be doing the summary courses, but if you want to read alongside, you're most welcome. Now, when I said freedom rights, when I say rights of freedom, it comes under Article 19. And when I say Article 19, we have 6 freedoms. Now, 6 freedoms? Why do I say 6 freedoms? Because although the original constitution was written as Article 19(1) A, B, C, D, E, F and G. In other words, there were 7 freedoms under Article 19. However, the 7th one, or rather the Article 19(1) F, has now been repealed by the 44th Constitutional Amendment Act 1978. So you might be wondering what was that. So that right was the right to property. So in the original constitution, so to say, in the original constitution, there were 7 fundamental freedoms that were given under Article 19. That was A, B, C, D, E, F, G. F, the Article 19(1) F has been repealed. Repealed means it has been removed by the 44th Amendment 1978. So if I minus 1, as of today, there are 6 fundamental freedoms given under Article 19. Now the first one is Article 19(1) A. So it is Article 19(1) A. It is freedom of speech and expression. This is amongst those freedoms which are most controversial. Usually it is always debated. Why? Because on the one hand, I as a citizen love my fundamental rights. I want to express through speech and my expression in other ways also. It's a very important, it's a very precious right. And I hope you remember, fundamental rights were nothing else but something that were ensuring human existence. So now I wonder that can I do and express by speech or by words, writing, printing, painting, lithography or any other means as the words have been interpreted by the Supreme Court? Can I utilize any kind of freedom of speech and expression, or is there any limit to it? Now this is always going to be a tug of war. On the one hand, the state would ensure that there should be limit, but who determines the limit? Because I would like my freedom of speech and expression to be practically unlimited, but the state would like to create a limit to it. Now this tug of war will continue. Yes, of course, this tug of war is going to continue, but the judiciary will be interpreting it in its own way, that whether the restrictions placed by the state, I'm repeating the word, whether the restrictions placed by the state on the citizens with regards to the freedom of speech and expression, are they reasonable or not? Now that brings us to the next point, that who has written these reasonable grounds of restriction. So under Article 19 subclause 2, there are reasonable grounds of restriction. So what are they? Yes, you can exercise your freedom of speech and expression, but don't go against the sovereignty, security, unity, integrity of India. Don't damage the public order, public peace of India. Don't do defamation. Don't do contempt of court. Don't hurt India's foreign relations. Don't go against decency and morality. And also don't do incitement of offense. So I am very, very happy about noticing this, that the same constitution which is giving me freedom of speech and expression is also giving me certain grounds of restriction. And these grounds of restrictions are very important. But whether these grounds of restrictions are reasonable or not is a $1 million question. And that is what the tug of war is all about. So every now and then, and when we do these courses, when you join me on Unacademy Subscription, we'll be able to discuss many of these courses, many of these landmark judgments, classical judgments of the Bennett Coleman versus Union of India cases and the Suckle newspapers cases and so on and so forth, where we notice that it was very important that the Supreme Court acts as an unbiased manner. Okay, it is an unbiased manner whether the grounds of restriction that have been placed on the citizen, are they reasonable or are they arbitrary? And mark my words, when I say about freedom of speech and expression, look at the language. It says that you can express your views, opinions and beliefs by words, writing, printing, painting, lithography or any other means. That also looks at, when I say the word any other means, that will also be inclusive of Twitter and Facebook and the information technology and the same way of social media and so on and so forth. So if you are very aware of this landmark judgments which we discussed too much in detail at later stage, is what is called as the Shreya Singhal versus Union of India case, popularly called as the Twitter Facebook case. In that case also, the Supreme Court placed on it came under the judicial scrutiny was section 66A of Information Technology Act. Again coming to the same point, are the grounds of restrictions upon the citizens, are they reasonable or are they arbitrary? Now, in this entire context, if I repeat this line, so at the cost of repetition, I'm repeating the same line. I'm saying words, writing, printing, painting, lithography, and any other means. Yes, I'm repeating the same thing. Now, do you realize that the word freedom of press does not appear under Article 19? Now, that brings me to another question. Do we have freedom of press or not? The idea is, if I go and look at Constitution of USA, if I look at Constitution of USA, then I will notice that freedom of press is expressly mentioned in the Constitution of USA. While if I look at it in India, then freedom of press is implicit. It is implied. You are hiding it from the words. Nowhere in the Constitution of India is the word freedom of press actually written as PRESS, freedom of press. No, but you can understand that. I am not saying that we don't have freedom of press. I am just saying that here we are implying, and over in USA it is expressly mentioned. The next one is Article 19(1)(b). That is freedom of assembly. Now, as the name suggests, assembly means coming together. So you as citizens have the freedom to take out marches, processions, rallies. Alright. Now, the word that is used in the Constitution is very, very beautiful. It is that this assembly should be peaceable and without any arms. Now that is a very beautiful line. Why? Because your freedom of assembly can also be placed under reasonable ground of restriction, which is section 144 CRPC can be utilized to enforce that. So during this coronavirus lockdown, this is something that you must have heard of much often. In fact, at various places in India, even as of now, there is section 144 Criminal Procedure Code already in force. So what is 144 CRPC? I've already made a detailed video of that on YouTube. You might as well like to watch that video. However, what is section 144? That by an executive order, the district administration can place that particular district or a few police stations in that district as required under what is called as the curtailing of assembly. What does that mean? There can be restriction of X number of people. That number can be decided. X number of people, usually 5 or more than 5, are not allowed to assemble. Now that could raise a question mark. Sir, if you are not allowing me to assemble, then what about my fundamental right? Please mark my words and write it down someplace. Fundamental rights are not absolute in nature. Fundamental rights are also allowed to be placed under what are called as reasonable grounds of restriction. So section 144 Criminal Procedure Code order, that is an executive order, is not considered violative of Article 19. It is in fact well within the grounds of reasonable grounds of restriction. So what are the reasonable grounds of restriction? This could be sovereignty of India, that is security of India, integrity of India. Public order is a very important part of restricting the freedom of assembly. This is very, very important to note again, that when I say that you can take out marches, you can take out processions, you can take out rallies, but under all circumstances, you have to be careful that any of these grounds of public order, security of country, etc. can be placed on record and make this freedom of assembly be placed under reasonable grounds of restriction. This is another important thing, that when we are reading, we completely go in our own thought process, okay? And we think that if you are allowed to take out marches and you are allowed to take out processions, then you might as well have the right to strike. Please understand, topper material question. Read this part and remember this. Supreme Court has analyzed this, and Supreme Court has decided that by no stretch of imagination can freedom of assembly be construed as to be understanding or to be interpreted as it consists of right to strike. No. Right to strike is not your fundamental right under any circumstances. It does not come under freedom of assembly. The third is freedom of association. So Article 19(1)(c) is freedom of association. Now what is this freedom of association says? Freedom of association says as citizens you can form groups, you can form associations, you can form companies, you can form political parties. These are all your fundamental rights. Now that brings us to a new question. Does that mean, sir, that I can form any association and there is no ground of restriction? No. Again repeating the same thing and again repeating, fundamental rights are not absolute rights. Certainly they are not absolute rights, and fundamental rights can be and should be placed under reasonable grounds of restriction. So there is again security of India, public order and morality. These are three reasonable grounds of restrictions on the basis of which I can restrict your freedom of association if I am the state. Okay, so what is not allowed? Any illegal association, not allowed. Any anti-national association, not allowed. Any organization which is immoral, so to say, is not allowed. So drug cartels, mafias, gangs, these are not allowed. Terrorist organizations, certainly not allowed. And how will you manage that? No problem. We have different acts like the Unlawful Activities Prevention Act of 1967, which has been amended in 2019. I'm sure that you are aware of this current affairs. If not, I've already made a video of that. Please watch that video. So Unlawful Activities Prevention Act of 1967 as amended in 2019 allows the central government to declare your organization or any such organization which is either hampering the security of India, public order or morality as a banned organization. So you must have heard of several terrorist organizations being declared as banned organization. So all the assets of such a organization will be frozen, and this is also a reasonable ground of restriction. So you cannot go to the Supreme Court and say that our freedom of association has been taken away. No problem. While reasonable grounds of restriction can be placed on your fundamental rights. Now you have freedom of movement and freedom of residence. Now both of them I would suggest that you read together. Why? Because both of them are practically having same reasonable grounds of restriction. Okay, both of them can be restricted. Freedom of movement as well as freedom of residence can be restricted on the basis of, number one, in the interest of general public, and number two, in the interest of scheduled areas. Now when I say general public, I hope you're understanding it becomes a huge line. Now first of all, let's look at Article 19(1)(d), that is movement, and Article 19(1)(e), that is residence. Freedom of residence and Article 19(1)(d) and movement under Article 19(1)(d) and freedom of residence under Article 19(1)(e) has same reasonable grounds of restriction. First important point that you notice is that freedom of movement is, as given under Article 19(1)(d), is within the territory of India. Make no mistake about it. If you cross borders of India and you're coming back to India, if that is the movement that you are looking for, then it is not under Article 19. Then it is under Article 21. But if you're looking for the movement within the territory of India, then it is falling under freedom of movement of Article 19(1)(d). Another important part is neither directly nor indirectly. I'm repeating this line. Neither directly nor indirectly can you take away freedom of movement. Now what would that mean? So one simple way, suppose I am the state and I want to take away your freedom of movement. One simple way would be to barricade the entire area, stop the railways, stop roadways, stop airways or whatever way. This is called as express. What is this called as? This is called as express blockage or express taking away of freedom of movement. But in contrast, there could be an implied way also. Implied ways, I make exorbitant taxes or I increase the charges of railways so badly that it becomes impossible for you to move. Both of them are restricted and both of them are not allowed. Both of them should be only within the reasonable grounds. So curfew, you must have heard of this. Lockdown, the ones which we are facing right now because of coronavirus pandemic. Is it taking away your freedom of movement? 100%. But is it violative? Certainly not. Why? Because the state is well within its powers to ensure that the freedom of movement can be curtailed if it falls within the reasonable grounds of restriction. So curfew, lockdown, these are all allowed if they fall in the reasonable grounds of restriction. As I said, there are two reasonable grounds. One is in the interest of general public, the other one is in the interest of scheduled areas. So now I hope you have understood how I am taking you. How are you going to connect things? So what is happening contemporarily? What is happening around you? How are you going to study for polity? That's how you study polity. This is called preparation. When you study the answer, when you write the answer, then your examiner gets impressed because you are understanding. I'm repeating again and again that you will not be given a single mark for facts. Most of the questions are now connected matters. You must be connecting one fact to another if you want to pass this exam. Similar is freedom of residence. Now again I am telling you, again it is within India, that any citizen has the freedom to reside in any part of India or any place within the territory of India. Now there are certain restrictions here also. That means there are reasonable grounds of restrictions also. So diplomatic areas, military areas, classified secret areas, protected areas, these are areas in which you cannot be residing. And of course there was a very important exception to that was Article 35A. So Article 35A, which I'm sure now rests in history after 5th August 2019, was the ones which gave special residence rights for citizens of Jammu and Kashmir. So this was Article 35A, which was giving special rights to the citizens of Jammu and Kashmir, that only they can buy property and land in the state of Jammu and Kashmir. Of course, you know now that after the parliamentary abrogation and the Jammu and Kashmir Reorganization Act, now this has become history. So now, as of now, we can say that the entire country, almost practically the entire country, comes under freedom of residence. So this, when I'm said almost, some of you might be doubtful about what is this almost, because there are certain other areas in India still which have got reasonable grounds of restriction with regards to freedom of residence. Of course, they come under Article 371 in certain states and in some other places for the protection of local interests, right? However, do not mix them up with Article 35A, which was specifically only for Jammu and Kashmir. Another and the last one is Article 19(1)(g). It says freedom of profession. It says that any person is free to take up any occupation or do any kind of trade, any kind of profession. Now this is Article 19(1)(g). Now this is slightly to be studied in detail, in the sense that there are reasonable grounds of restriction here also. So for example, there are certain academic qualifications that you need. Of course, then illegal and immoral professions will not come under this ambit. Also, when you will be able to join me on my subscription, I'll be able to explain a very famous eclipse, which is called as very famous doctrine called as the doctrine of eclipse, which comes into force that whether the state can monopolize a particular profession or a particular trade or not. So the Honorable Supreme Court has dealt with this in huge details in what are pre-constitutional laws and post-constitutional laws. As of now, please understand, for your limited understanding, because this is not given in Laxmikanth by any standards, okay, you must understand that only pre-constitutional laws must be dealt by under doctrine of eclipse. But minus that, except if the state wants to monopolize a particular business, you have all the freedom to take up any occupation or to practice any trade or any business. This is freedom of profession. This is provided under Article 19(1)(g). Okay, so these are the different articles which are given under freedoms which are given under Article 19. A very important part for all of you to remember. Article 19 stands on a completely different footing. Why do you say so? Because Article 19 gets automatically suspended during external emergency, but it can never be suspended during internal emergency. So with Article 19, as I said, we always discuss it on a different footing. Article 19 gets automatically suspended during external emergency under Article 352, and the moment our emergency is revoked, it will come back. But with regards to internal emergency under Article 352, Article 19 can never be suspended. This is a very crucial component of Article 19, which differentiates it from all other fundamental rights. So my friends, in the summarization, I said freedom rights are not absolute and you can place reasonable grounds of restriction. I want you to read all these articles one after another and make sure that you are able to draw connections. In the limited period of time that we can dedicate to the reading of these or summarizing these Laxmikanth topics, on a YouTube channel, this is what I can deal with you. Of course, I welcome you to join me on my Unacademy subscription, where we'll deal with this in far more detail and you will get a rock solid preparatory attempt at your exam. This is the name of the course, the comprehensive course on polity for UPSC CSE 2021. It is starting on 11th May. May 11th we are starting, and if you want to join, use the code SIDLIVE or SID10, whichever, and in both the cases you'll get an immediate 10% discount. In the words of Unacademy, my friends, let's crack it. And until next time, God bless and thank you.